Hello friends, in the series on the income tax cases, today we will discuss an issue which is based on deemed dividend. The concept of deemed dividend was brought in because it has been observed by the revenue department that the companies were transferring heavy amounts of money in the form of loans, advances to the various shareholders to give them some benefit. So, in order to avoid this practice that the profits available to the company should not be distributed in a wrong manner or which is not as per law to the various shareholders who are having substantial shareholding in the company, the concept of deemed dividend was brought in that if any advance will be given to those shareholders, then it will be taxed under section 2 clause 22 clause E as deemed dividend. But as a safeguard, the concept of deemed dividend excludes those transactions which are in the nature of trade transactions and those transactions which are in the nature of commercial transactions. But after the introduction of this provision, the assessing officers were getting every amount included in the definition of deemed dividend if that amount is received by the shareholder from the company, whether without going into the integrity, whether that amount is received in lieu of some commercial transactions. So, in what cases and what are the exceptions to the deemed dividend? This issue has been well taken up by Honorable Delhi High Court in the case of Principal Commissioner of Income Tax versus Dwarka Prasad Aggarwal. And this case has been reported in 471 ITR at page number 432, and the case has been decided on 13th February 2018. In the present case, the assessee provided security by way of mortgage of his personal property for obtaining the loans from the company. When the assessment proceedings of the assessee were going on, the assessee was show-caused to explain that why this amount of advance or loan received by the assessee should not be taxed under section 2 subsection 22 clause E. The assessee said that this advance has been received as a loan, the assessee is paying the interest on that, it is a commercial transaction, so it does not cover in the definition of the deemed dividend. But the assessing officer made the additions, and when the matter came to the CIT appeal by relying on the Central Board of Direct Taxes circular, which is 19/2017 dated 12th June 2017, according to which the assessing officers were guided that those transactions which are in the nature of trade transactions and which are in the nature of commercial transactions should not be included into the definition of advances which is given in section 2 clause 22 clause E. Since in the present case the assessee has received the advance or the loan by mortgaging his property, so at the face this transaction was a commercial transaction and should not be covered into the definition of advance as per section 2 subsection 22 clause E. Tribunal also gave the relief to the assessee, but the department moved to the High Court, and the High Court also said that in the present case the advance which has been received by the assessee does not come into the definition of deemed dividend. The High Court said that this type of transaction, though facially suspicious, had been sufficiently explained by the assessee and it does not come into the definition of deemed dividend. In the present case, one more issue was there. The assessing officer has made additions for some sundry creditors on the basis of the definition of the statements of the directors, because the assessee has received some amount and the directors of the company have given some negative statements. Although the assessee has explained those transactions well by submitting the bank statements, confirmations and the identity of the creditors, but in spite of those submissions, without making any further inquiry, the assessing officer made the addition just by relying on the statements of the directors. So on this also the court said that in the present case the section 68 does not apply, since the assessee has sufficiently discharged his onus to explain the nature of the transactions and the genuineness of the transaction. So when the assessee has discharged his initial burden, then it becomes the responsibility of the assessing officer to prove that that explanation given by the assessee is wrong or not as per the law. So the additions made by the assessing officer on the basis of deemed dividend and under section 68 for creditors which were already deleted by the Honorable CIT and Tribunal, the orders of the CIT appeal and Tribunal were upheld by the Delhi High Court. At the end of this video, once again I am repeating the name of the case. The name of the case is Principal Commissioner of Income Tax versus Dwarka, Prasad, Aggarwal, and this case has been reported in 471 ITR at page number 432, and the date of the judgment is 13th February 2018. Thank you, friends.